Today's lecture provides an introduction to the African human rights system. Here's an overview of what we'll discuss. I'll provide an introduction to the African Charter on Human and People's Rights and some of its key provisions. We'll then discuss the activities of the African Commission on Human Rights and some of the challenges the Commission has faced. And then we'll review some of the distinctive jurisdiction and access rules of the relatively recently created African Court of Human and People's Rights. Let's turn first to an overview of the African Charter. This is the most recent of the three major regional human rights systems. The Charter was adopted in 1981 and entered into force in 1986. And as of today, 2014, 54 African nations are members. That's virtually every country on that continent. The African Charter's provisions are quite distinctive. Some of them are quite similar to the civil and political rights and the economic and social rights that we have already studied, but the Charter also includes certain provisions on collective and development rights, as well as limitations and individual duties. We'll discuss some of those in the next lecture. Let's turn to an overview of the activities of the African Commission on Human and People's Rights. The Commission began operations in the mid-1980s when the Charter entered into force, and it carries out functions that should by now be quite familiar to you from your study of the other regional systems and the United Nations human rights system. The Commission reviews reports from states parties regarding their implementation and compliance with the African Charter. It conducts investigations of specific human rights issues and challenges in individual countries, and it reviews communications from individuals and NGOs, and in response to those communications, which allege violations of the Charter, it issues non-binding decisions and recommendations to states. Those are some of the Commission's key activities. How has the Commission carried out those activities in practice? Well, there have been a number of criticisms and challenges of this regional. One is that the Commission's work is given insufficient visibility, both its promotional activities and its decisions in response to individual or NGO petitions. There have been several instances of delays in reviewing complaints by those applicants and in issuing decisions, somewhat limited follow-up with states parties' human rights commitments and obligations. Decisions, of course, are non-binding, although that's true for the Inter-American Commission on Human Rights and the UN treaty bodies, and perhaps most notably, rather limited or sporadic compliance by states parties. Those are some of the challenges the Commission has faced. They might be attributed in part to the fact that it's a fairly new institution. They might also be attributed to the fact that human rights problems on the continent of Africa can be quite widespread. And they may also be attributed to the fact that the Commission does not have sufficient resources to carry out its mandate in the way that it would like. There are probably other explanations as well, but I think it's important for you to think about what those explanations might be and how they might be overcome. And indeed, that was one of the goals of ultimately establishing a regional human rights court for Africa. During the 1960s through, say, the 1980s, African governments were generally quite resistant to submitting themselves to the jurisdiction of a regional court that would issue legally binding judgments. Now, that wariness began to diminish with the end of the Cold War, the growing number of democracies in Africa. You should see some parallels here to the transitions we talked about in Latin America, the increasing visibility of human rights NGOs in Africa, and external financial and other forms of support for justice projects, including human rights. And so by the late 1990s, the decision was made to create an African Court of Human and People's Rights. As you can see from this timeline, the way in which the court was established was by virtue of the adoption of a protocol to the African Charter that would establish the court. That protocol took about 6 years until it entered into force. 2 more years passed before the court's first 11 judges were sworn in, and the first decision on admissibility was issued in 2009, and that was a decision dismissing a case for lack of jurisdiction. The first merits judgment, or first decision entertaining the merits of an allegation regarding the violation of the African Charter, was issued in the summer of 2013, and we'll read that decision in the next lecture and discuss it. I want to talk a little bit about the structure of the court's jurisdiction. Before doing that, I'd like to show you this photograph of the court, its judges, and staff at the court's headquarters in Arusha, Tanzania. Let's talk about the jurisdiction and access rules of the African Court of Human and People's Rights. So one question you might have is, which states have recognized the jurisdiction of the court to review complaints alleging violations of the African Charter? The answer to that question is that the court has jurisdiction over those states that have ratified the African Court Protocol. So, which are the states that have ratified the protocol? Here you see in green those states that have both signed and ratified the protocol. Those are the governments of about half of the 54 member states that have accepted the court's jurisdiction. A large number of other states have signed but not ratified the protocol. And if you remember from our discussion in week 1, signature indicates an intent to proceed to ratification, and ratification is the act that makes the treaty binding. So these countries have expressed some intention to eventually recognize the court's jurisdiction, but they have not yet done so. Now, let's talk about how a case actually gets to the African court once a country has in fact ratified the protocol. So how do those cases get to the court? Well, there are a number of different ways, as we'll see. The main way is that cases are referred to the court by the African Commission on Human and People's Rights. This is a similar procedure to what we saw in the Americas when the Inter-American Commission referred cases to the Inter-American Court. However, there's an innovation here that doesn't exist in the Americas, and that is that a state can file an additional optional declaration that authorizes the court to receive complaints filed by individuals and NGOs directly with the court. And that optional declaration you can see set forth in the combination of these two articles, Articles 5.3 and Article 34.6 of the African Charter. Article 5.3 refers to the ability of the court to receive cases directly before it in accordance with Article 34.6 of the Protocol. And 34.6 of the Protocol indicates that a state may make a declaration that accepts the competence of the court to receive cases in this context. And that is with regard to individuals and NGOs bypassing the commission and going directly to the court. You might wonder, if you were considering litigating a case, which states have filed that optional declaration, especially if you were an attorney, say, representing an individual or a member of an NGO that works on human rights matters. This might be quite important to you. And in fact, on the website of the African Court, you can find a document, which I've excerpted here, that shows that 7 states have accepted this optional power for the African Court to receive complaints directly from individuals and NGOs. So that's still quite a small number, but as you can see, there are some quite recent ratifications, with 2 in 2013, and I expect that this number will grow over time. That's what I'd like to cover by way of introduction to the African human rights system. I'll leave you with these resources where you can find out additional information.